You're familiar with the Fifth Amendment.
Yes, Senator.
And it is really the freedom clause of the United States. It was 4 years into being a nation when Congress and the states said, hey, we have to make sure that there's not an over-aggressive government in the future that deprives us of life, liberty, or property without due process of law. And you're familiar that that applies to all persons in the United States.
Yes, Senator.
So there's been a lot of concern about the several hundred immigrants who were swept off the streets of America and sent to El Salvador without due process. And does it
afford a due process? All the FBI did and all the FBI will continue to do is arrest those that have violated the law.
Okay.
The director of the Federal Bureau of Investigation was just asked whether the Fifth Amendment to the United States Constitution applies to all persons in the United States. He said he did not know the answer to that. The Fifth Amendment has been in the Constitution since 1791. It contains 14 words that are not ambiguous. No person shall be deprived of life, liberty, or property without due process of law. Not no citizen. Not no legal resident. No person. That language has been interpreted by the Supreme Court, the Federal Circuit Courts, and the District Courts of this country for over 200 years. The answer to whether it applies to all persons is not a matter of legal debate among people who have read it. It is the first sentence of one of the most foundational legal protections in American history. The director of the Federal Bureau of Investigation, the agency whose core function is to investigate violations of federal law and uphold the constitutional rights of the people it serves, said he did not know the answer to whether that protection applies to everyone. And then he said something else. Something that will be the frame for everything that follows in this documentary. He said he was not a constitutional scholar. The man who swore a constitutional oath, leading the agency built to enforce constitutional protections, said he was not a constitutional scholar when asked the most basic constitutional question a senator could ask. That is where this story begins. And by the time it ends, you will understand exactly what that answer revealed about how the Federal Bureau of Investigation is being run in 2025. To understand why Merkley asked that specific question to the FBI director on that specific day, you need to understand what was happening in the weeks before this hearing. The Trump administration had been using the Alien Enemies Act of 1798 to deport individuals to El Salvador. That process had moved at extraordinary speed. People were taken from the streets of American cities, placed on planes, and transferred to a maximum security foreign prison before many of them had any opportunity to contest their detention in court. The Supreme Court of the United States had issued a ruling indicating that individuals subject to these deportations were entitled to due process, to notice and an opportunity to be heard before removal. The administration continued the deportations. One specific case had become a focal point. Abrego Garcia, a Maryland resident, was deported to El Salvador. The administration acknowledged the deportation had been a mistake. A federal court ordered his return. The Supreme Court weighed in. As of the date of this hearing, he remained in El Salvador. These were not abstract constitutional debates happening in law school classrooms. They were active federal cases involving real people, active Supreme Court orders, and active defiance of those orders by executive branch agencies. Senator Merkley wanted to know if the director of the FBI, the agency responsible for investigating violations of federal law, understood that the people at the center of these cases had constitutional rights. The director said he did not know the answer to that.
Of the Freedom Clause of the U.S. Constitution?
Senator, I don't know that I agree with your characterization.
Well, that was my first question, whether or not you agree with the Fifth Amendment and are prepared to defend it. It is your job to investigate crimes.
Yes, I agree with the Fifth Amendment. I agree with the entire Constitution, and the men and women at the FBI decide.
So are you going to launch an investigation of the reported violation of the due process of several hundred individuals?
Again, Senator, it's not for me to call the balls and strikes on it. The men and women at the FBI who are trained to open investigations will make those calls.
So you have
Not for me to call the balls and strikes. That phrase is important enough to slow down on. Because it sounds reasonable on the surface. It sounds like institutional humility. Like a director who understands the limits of his role. But here is what it actually means in this specific context. The FBI's core mandate is to investigate violations of federal law. Federal law includes the constitutional rights protected by the Bill of Rights. When those rights are violated, the agency with jurisdiction to investigate is the Federal Bureau of Investigation. Senator Merkley was not asking Patel to be a judge. He was not asking him to rule on whether the deportations were legal or illegal. He was asking whether Patel planned to fulfill the basic investigative function of the bureau he leads, to examine whether federal constitutional protections had been violated for several hundred people who had been removed from the country without due process. Calling the balls and strikes is the job. That is specifically and precisely what the FBI director is empowered to do under federal law. When Patel said it was not for him to call the balls and strikes, he was not displaying humility. He was describing a version of the FBI director's role that does not include investigating potential constitutional violations by the executive branch of the government that appointed him. That is a specific institutional position. It is one with significant legal and constitutional implications. And it was stated under oath in a Senate committee hearing. Merkley heard it exactly as it was meant. His response was 3 words. You haven't read it. On February 20, 2025, the day Kash Patel was confirmed as FBI director, he took an oath. That oath is not long. It is 1 sentence. And it does not contain any qualifications about constitutional scholarship. It says, I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic. Support and defend. Not interpret. Not evaluate. Not call balls and strikes when convenient. Support and defend the Constitution of the United States. The Fifth Amendment is part of that Constitution. The Supreme Court's due process rulings are expressions of that Constitution. The federal court orders in the Abrego Garcia case are applications of that Constitution. When Merkley asked Patel if he was familiar with the Fifth Amendment and prepared to defend it, he was asking the director of the FBI whether he intended to do what he swore to do on the day he took office. Patel said he was not a constitutional scholar. He is not required to be a constitutional scholar. He is required to have taken the oath and to act on it. Those are 2 different things. And that difference is where this entire exchange sits. But here is what makes this moment more significant than just a tense Senate exchange. Because Merkley did not stop at the Fifth Amendment. He had more questions. And the pattern that emerged across all of them is what this documentary is built around. Stay with us. Because what came next in that hearing room reveals something about how the current FBI director understands the limits of his own authority that no single clip has fully captured.
For me to answer.
The question has already been answered by the Supreme Court that they're protected. Therefore, it's a violation of law, and it's your responsibility to open an investigation. And you're saying today you will not do so?
I am not the agency involved in removal proceedings. That is a different branch of government.
So if an agency other than the FBI violates the law and the Constitution, you will not investigate because it's a different agency?
I will investigate every violation of law.
Well, you have, but you just said you're not investigating.
No. You and I are in disagreement on what is a violation of law. I have yet to hear from the Supreme Court your position.
Hilmar Abrego Garcia was a Maryland resident. He was deported to El Salvador. The Trump administration subsequently acknowledged the deportation had been a mistake. A federal court ordered his return to the United States. The Supreme Court of the United States weighed in, indicating that his due process rights had not been satisfied. As of the date of this hearing, he remained in El Salvador. That sequence of events is documented. It is not disputed. Even the administration's own lawyers acknowledged in court proceedings that the initial deportation had been an error. What Senator Merkley was asking was specific and narrow. Not whether the deportations in general were legal or illegal. Not whether immigration policy was right or wrong. He asked whether the FBI, the agency constitutionally empowered to investigate violations of federal law, had taken any action in response to what a federal court and the Supreme Court had characterized as a failure of due process. Patel's answer was to redirect to the Department of Justice. Here is why that answer has a structural problem. The FBI is the investigative arm of the Department of Justice. That is not a description of a separate institution. It is a description of the FBI's institutional role within the Department of Justice. Directing a senator to the Department of Justice for questions about FBI action is directing him from one hand to the other hand of the same body. And when Merkley pointed this out and asked directly who investigates when the executive branch defies a Supreme Court order, Patel said he was not in a position to characterize those actions as defiance. The Supreme Court had characterized them. Federal courts had characterized them. The administration's own lawyers had acknowledged the underlying error in court. Patel said he was not in a position to characterize that question, who investigates when the executive branch defies a Supreme Court order, is not a hypothetical. It is one of the most important structural questions in American constitutional government. The founding design of the American system assumes three co-equal branches. The legislative branch makes the law. The executive branch enforces it. The judicial branch interprets it. When the judicial branch issues a ruling and the executive branch does not comply, the system depends on accountability mechanisms to function. In the federal system, the primary mechanism for investigating potential criminal violations by executive branch officials is the Federal Bureau of Investigation. That is not an opinion. That is the institutional structure. When Merkley asked his question, he was pointing directly at that structure. If the executive branch is defying a Supreme Court order, and the FBI is the investigative arm of the federal government, then the FBI director should at minimum be able to say whether his agency has examined the situation. Patel said he was not in a position to characterize. He was not asked to characterize. He was asked whether his agency had investigated. Those are two different questions. And the distinction between them is exactly what the pattern in this hearing reveals. Because across every question Merkley asked, the Fifth Amendment, the due process investigation, the Abrego Garcia case, the Supreme Court order, Patel's response followed the same structural path. Acknowledge general familiarity. Decline to take a position. Redirect to another agency or another process. Avoid the specific answer the question actually asked for. That pattern is not nervousness. It is not imprecision. It is a documented, consistent approach to constitutional questions that the director of the FBI used across an entire Senate hearing. And it has a name in legal scholarship. Constitutional avoidance. The deliberate practice of declining to take positions on constitutional questions in order to preserve executive flexibility. Applied by the director of the Federal Bureau of Investigation, the agency whose job is to enforce constitutional protections, that practice does not represent humility. It represents a specific choice about which constitutional obligations are worth defending.
A constitutional scholar.
Well, it's actually not it's a question also of law.
But your position is that every one of those individuals is by constitutional right afforded due process. I don't know the answer to that. I'm telling you.
You haven't read the Constitution?
I've
It
got
says
it right,
all persons.
I've got it right here, but what you're saying is that every single one of the illegals that was sent down to El Salvador is supposed to be given due process pursuant.
Yeah, that's what the Constitution says. It says no
doesn't
person.
say that.
It does say no person. Yeah, I'll encourage you to read it because it's also
read it
been
every day.
affirmed by the Supreme Court.
Senator Merkley's final line in that exchange is the one that deserves the most attention. You do not need to be a constitutional scholar to defend the oath you took. That is true. And the historical record of FBI directors shows exactly what it looks like when the person at the top of the bureau takes that principle seriously. Robert Mueller led the FBI from 2001 to 2013. He was a former Marine officer and federal prosecutor who had spent his career inside the legal system. When the Department of Justice under the Bush administration attempted to authorize warrantless surveillance programs that Mueller believed violated the Constitution, he threatened to resign. He drove to a hospital to prevent officials from getting the Attorney General to sign an authorization Mueller believed was illegal. That documented confrontation is part of the official Senate record. James Comey, whatever controversies surrounded his tenure, publicly stated on multiple occasions that the FBI director's most important obligation was to the Constitution, not to the administration that appointed him. Neither of those directors said they were not constitutional scholars when asked about constitutional protections. The position of FBI director has historically been occupied by people who understood that constitutional expertise is not a prerequisite for constitutional commitment. You are not required to know every precedent and every circuit split. You are required to understand that the document you swore to defend says all persons, and to act accordingly. What Merkley was pressing on in that hearing was not legal knowledge. It was institutional will. The willingness to say, yes, the Fifth Amendment applies to all persons, and if those protections are being violated, this Bureau will look at it. That answer never came. Here is the complete oath audit. On February 20, 2025, Kash Patel swore to support and defend the Constitution of the United States. On May 8, 2025, 77 days later, he told the United States Senate he did not know whether the Fifth Amendment applied to all persons. He told the Senate it was not for him to call the balls and strikes on whether constitutional protections were being violated. He told the Senate he was not a constitutional scholar when asked if he was prepared to defend the oath he took. He told the Senate he was not in a position to characterize whether the executive branch's defiance of a Supreme Court order was defiance. He told the Senate that questions about FBI action in response to a documented constitutional failure should be directed to the Department of Justice, which is the department the FBI is the investigative arm of. 5 answers. 1 hearing. 77 days after swearing to support and defend the document those answers were about. The gap between the oath and the answers is not a matter of constitutional scholarship. Senator Merkley made that clear in the most precise sentence of the entire exchange. You do not need to be a constitutional scholar to defend the oath you took. What the gap reveals is a specific institutional posture. The FBI under Kash Patel does not investigate constitutional violations by the executive branch. It defers to the executive branch on questions about whether the executive branch's actions were constitutional. It redirects constitutional questions to the department that appointed it. That posture has consequences. For the people whose due process rights were at issue in those deportations. For the legal principle that no branch of government is above judicial review. And for the institutional independence that has made the FBI a credible law enforcement body across 12 administrations. Whether those consequences are acceptable depends on a value judgment about institutional independence that every American is entitled to make for themselves. What is not a value judgment is the documented record. The oath exists. The answers exist. The gap between them is on the permanent Senate record. 2 questions for the AVA reports community. The first. The FBI's constitutional mandate includes protecting civil rights and upholding due process. Senator Merkley asked the FBI director if he would investigate potential constitutional violations by the executive branch. Patel said it was not for him to call the balls and strikes. Do you believe that answer is consistent with the FBI director's constitutional obligations? Or do you believe the director's role requires deference to the executive on questions about the executive's own constitutional conduct? The second. Robert Mueller threatened to resign over a constitutional question in 2004. Patel said he was not a constitutional scholar in 2025 when asked the same category of question. Does that comparison change how you evaluate what the FBI director's institutional role should be? Yes or no, and tell me why. Drop both answers below. This community reads them. This is exactly the kind of debate this channel was built for. Subscribe to AVA Reports. Hit the notification bell. The next documentary covers the legal case that will force these constitutional questions out of hearing rooms and into federal courtrooms where the answers must be documented. Thank you for watching.